Our thanks to Frank and Ryan for those reports. Earlier today, prosecutors and defense lawyers made their closing arguments in the criminal trial of Kyle Rittenhouse. Rittenhouse is an 18-year-old charged with homicide. He fatally shot two protesters during an instance of unrest last year in Kenosha, Wisconsin. According to AP News, Rittenhouse's lawyer said he was acting in self-defense when the then 17-year-old shot three people with his AR-15 rifle. The teen also went on the stand saying he feared for his life. The deadly incident took place last year on August 25th when Rittenhouse was driven to Kenosha by his mother with the AR-15 style rifle. Rittenhouse lives in Antioch, Illinois, which is at the state line of Illinois and Wisconsin. He told the court he went to the protest to be a medic and help protect private property. Before the jury took over the case for deliberations, the judge broke down the method of how the case should be decided.
The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person.
Joining us to discuss the latest in this trial is John Tolley, a former prosecutor and insurance defense lawyer licensed in New York, New Jersey, and Florida. He has tried over 20 criminal and civil injury trials. He is the co-owner and a partner in JT Law Firm, where he represents clients in disputes regarding homeowners insurance, personal injury, and criminal defense. Mr. Tolley, thank you for joining us.
Thank you so much for having me.
Okay, so first off, there are a lot of points to focus on with this trial, but can you first break down this case for our audience listening?
Sure, and that's the biggest job of an attorney. I've practiced as a prosecutor and as a defense attorney, and really it's to take all of these complex issues and boil it down into a couple specific facts that the jury has to decide on. So you have a case here where self-defense obviously is the main issue or the main crux of the case for the defense and for the prosecution. So obviously the prosecution brought forth evidence in this case that Mr. Rittenhouse was using deadly force to protect property, which is not an exception under the law, and thus he's not entitled to self-defense and should be convicted of murder. Whereas the defense attorney is saying he was there to protect property originally, but then when chased down by the eventual victims, he used deadly force to protect himself from great bodily harm or death. So that's kind of the main issue or the main crux of the case.
Now, based on the trial, do you think the defense has made valid points that could help Rittenhouse's case?
Well, I've tried over 40 jury trials, and I'll tell you this. The cases that go to trial usually have good points on each side. You're not going to usually have a case, unless it's a case where you're seeking the death penalty against someone, where you have a slam dunk, right? So obviously I think the defense made some valid points, especially on cross-examination of one of the victims who was fortunate enough to live, in terms of painting a picture to the jury that when Mr. Rittenhouse fired his gun, that he had a basis to be fearful for his life. Obviously you're not allowed to ask the jury to step in the shoes of Mr. Rittenhouse, but what you can do is you can kind of walk up to that line. So they wanted to paint a picture where that night was very tense, that he thought he was going to lose his life, and as a result, he pulled his firearm. And being a criminal defense attorney now, obviously dealing with self-defense cases, that's your job, is to make it seem as though that was a very reasonable action for him to take. And I thought that they brought up some very good points on cross-examination, specifically that, one of the victims had a firearm, that they admitted that they chased him down. So that's helping them paint that picture of a scenario where he was the hunted instead of the hunter.
Across various social media platforms, some people are demanding that Kyle's mother should also be arrested and brought in on charges because she drove her 17-year-old to a protest in another state with a deadly weapon. Can she face any charges for this?
So you can do anything, right? Potentially she could face charges for accessory before the fact, or a co-conspirator. But the problem that you might have with that is that one of those essential elements of that is kind of a foreseeability thing, right? By her dropping him off with that firearm, it was a reasonable person likely to foresee that he would use that in the commission of a murder. So I think where you're likely to see that is if he is in fact found guilty of the murders, then potentially the prosecutors are talking about a scenario where they bring her as an accessory before the fact because they gave him the means to commit the crime. But I don't think we'll see any type of charges, at least until after there's a decision by the jury, and we should have that, obviously, within the next couple days or maybe early next week.
Mr. Tolley, thank you so much for joining us.
Thank you.